Has anyone, let's start with you, Mr. Handte, has anybody threatened you or somebody you care about with physical harm, for example, to make you plead no contest against your free will?
No.
All rise. The Second Judicial District Court, the state of Nevada is now in session. The Honorable Barry Breslow presiding.
Thank you, Deputy. Good morning, everyone. Please be seated. All right, good morning, everyone. Welcome to Department 8. We're on the record in State of Nevada versus Roger Hillygus and State of Nevada versus Stewart Handte. The case number CR 19-1535A and B. The court is here with Mr. Stege, the prosecutor, both defendants, Mr. Silverberg on behalf of Mr. Handte, and Mr. Goodnight appearing for purposes of the portion of the hearing today on behalf of Mr. Hillygus. Several things to go over that I have identified. The court's list may not be complete, but here goes. The first thing is, Mr. Stege, the court noted that the state of Nevada recently filed an amended information. What did the amended information do that the information did not, please?
First of all, at the time this case was charged, there was no NRS assigned to the crime of delivering simulated legal documents. That's been amended now by the information.
So wait, when you say there was no NRS, like was an oversight was not in there, or there was a statute that's been revised?
It was cited in the complaint as I believe, the assembly bill, because it was a recently passed, so it had not yet been, I guess, I'm forgetting the term, sort of placed into the NRS.
Got it.
So that's been.
But it has now.
It has now, right? And so, of course, the law, we're allowed to amend as long as we don't add new charges or theories, and it's not to the detriment of the defense. No prejudice there. As well, in the burglary charge had surplus language. Specifically, it had language related to the elder enhancement, which it's not possible to assign the elder enhancement to that offense, so that language was removed from there.
In your mind, do either or both defendants need to be rearranged based on any of these changes?
I don't think so. I think it's contemplated that, right? No new charges, no changes to any theories. It's now, I've now laid out my reasons or the changes. It does not sort of affect any substantial right.
Okay, thank you. And just making sure everybody's microphones are on green right now. If they're not, please put them on. And also slide one near Mr. Hillygus. All right, thank you. All right, Mr. Hillygus, you just heard the state. It filed an amended information, an amended document that charges you and Mr. Handte. It doesn't add any charge. It doesn't add material facts. It actually withdraws some of the charge or some of the background with respect to the burglary, and it clarifies that what was at the time an assembly bill has now been turned into law and assigned a Nevada revised statute number. The court's belief is it doesn't affect anything we've done to this point. It clarifies things, and you don't need to be rearranged. Do you have a position on that? If so, what is it?
I do have a position on that, and it's that they were able to go 4.5 years charging me with an assembly bill. If this is ex post facto, they're leaving out documents intentionally, deceiving the court. They're calling these documents from we the people that started filing.
Hold on. This is a different issue. The question is procedurally. Do you believe you need to be rearranged? When the change was, it didn't say we're now bringing a new charge against you. It didn't say we're changing the operative terms against you. It didn't do anything to adversely affect your rights. So do you believe that you need to be rearranged? It's really a yes or no question, sir.
I believe the state needs to be sanctioned for charging somebody with an assembly bill, which is impossible. You can't charge somebody with an assembly bill for 4.5 years and then all of a sudden decide to just change it and say, oh, well, now we're deciding to change this. So in my opinion, the state needs to be sanctioned for having a professional team. As you told me, these are professionals. They got hundreds of people working on this case. and they let this go for 4.5 years, charging me with an assembly bill.
All right, your concern that it took this long is noted. Mr. Silverberg, on behalf of Mr. Handte, a position on whether Mr. Handte needs to be rearranged.
I don't believe he needs to be rearranged. I know he was concerned that somehow he was added into the document charges against Mr. Hillygus.
I don't think he was.
I agree. I assured Mr. Handte of that, but I wanted to bring it up to the court so the court could assure Mr. Handte of that as well.
I assure Mr. Handte that no new charges have been brought against him by virtue of the amended information. I looked it over very carefully to determine, among other things, if that were the case, but it's not. It's to do the two things that the state indicated. The assembly bill turned into an NRS, which they now know, and also with respect to the burglary charge, to clean that up a bit.
Thank you, Your Honor.
All right, let's move off that. I want to talk now about,
It's still not signed, which is a requirement under NRS, and so the information is still in violation of NRS because it has not been signed.
well, the one that was filed, Mr. Stege, did not contain an electric signature, and it needs to. Please refile it. If you think it's okay as is, leave it alone. Let's move on. I asked Mr. Goodnight to be here because this is again, we've been to this point in time on the calendar twice now. The other time was in August, where we were, as I recall, on the Wednesday before the Monday trial, at which time, at the final pretrial conference, the court examines this investigator the prosecutor, as to any offers to resolve this matter that have been made and to ensure that they were communicated to the respective defendants. That's Fry versus Missouri. The other case that I want to talk about is, and I never really know how it's pronounced. It's at Lafleur versus Cooper, LaFleur versus Cooper. In any event, it's the 2012 U.S. Supreme Court case, we'll say Lafleur versus Cooper, which is used often by trial judges to ensure that not only was an offer communicated, but that counsel, if there is counsel, has discussed the offer with the client and made sure that client understands the nature of the offer and the substance. So let's go back, Mr. Stege, to any offers the state has made, sort of latest and best offer to resolve this matter to Mr. Handte. When was it made, and please, what was the substance of the efforts to resolve?
Yes, Your Honor. So after the court dates that Your Honor just mentioned, I caused to be filed on October 26th. It was styled Notice of Available Plea Negotiations, which gave both defendants a package negotiation that...
Was it conditioned on both had to accept in order for the state to agree?
As in the underlying crime, one for all for one.
All right, so then as to Mr. Handte, what was the offer that was communicated?
So long as he signed and filed the guilty plea by November 9th. That,
Hold there, was it a guilty plea or a no contest?
his allowed for a nolo contendere, no contest.
All right, and then if as long as he signed it by then, what would the terms be?
The terms were that the state would not oppose probation if you were to plead guilty to...
No contest?
I'm sorry, no contest to the count of burglary, a 1 to 10 felony with an, I'll read it from the draft guilty nolo plea. The term of probation shall be for a term not to exceed 3 years. The parties are free to argue all their terms, conditions, and the underlying sentence of probation. Upon entry of plea, the state will agree to release the defendant from GPS monitoring. The remaining release conditions are to remain in effect. If the defendant successfully completes probation, including earning an honorable discharge, he may withdraw his plea and plead guilty or no contest to conspiracy to commit burglary, a gross misdemeanor offense, and receive credit for time served. This negotiation is conditioned on both defendants entering pleas that resolve the case.
Okay, hold please. So the first question for you, Mr. Silverberg, did you receive that offer, as you recall?
Yes.
Was it discussed with Mr. Handte?
Yes.
And did he reject it?
Yes.
All right, and I want to make sure I understand for the court's edification here. The offer was, in the event that Mr. Handte and Mr. Hillygus both accepted the plea negotiations. The state would accept to resolve this matter, assuming court approval, a no low contend rate plea to a single felony, burglary, 1 to 10.
Yes.
But at time of sentencing, because even a no contest plea, after a proper canvass, if the court accepts that, the court would adjudicate Mr. Handte guilty. And then the state would not be asking for prison. The state would not be asking for a jail. The state would not object to, at the time of entry of plea, removing the GPS monitor. And further, that if he succeeded on probation for a period of time, not to exceed 3 years, that Mr. Handte could come back in, withdraw his guilty plea to the, withdraw his no low contend rate plea to the felony, and plead no contest to a gross misdemeanor and be sentenced to time served.
That is our understanding.
And Mr. Handte declined to go forward with that negotiation. In other words, no prison, no jail, no felony, no GPS monitor on his ankle.
Some of which I understand, Judge, the other charges were not delineated in that plea agreement. The 2 other charges.
Well,
No, they don't go away.
hold on. You know, let's make sure we understand the court's role. I'm not advocating, I'm not insisting, I'm not pressuring, I'm trying to understand. So here's what I understood. In the event that both defendants, not just you, Mr. Handte, both have to agree, or the state says we have no deal. But if both sides agreed, both defendants agreed, then the state would recommend that the court accept a no low contend rate plea to a single felony. The others would be dismissed. Is that right, Mr. Stege?
Yes.
And then, at that time, the GPS monitor comes off. Not at sentencing, but at the time of plea. Do I have that right, Mr. Stege?
Yes.
Okay. Then, at time of sentencing, the state would not ask for prison. Do I have that right, Mr. Stege?
Yes.
A suspended sentence, but not a sentence to be effected for him to take Mr. Handte into custody and direct him to the Nevada Department of Corrections at that time.
That was a negotiation.
All right, and so probation either for, up to, but not more than 3 years. And then if he honorably was discharged from probation, which means, no, don't pick up new crimes, no drugs or alcohol.
Well, I see that as, that's a legal term that we use.
He would just have to honorably graduate.
Yes.
Right, so you have to honorably graduate, but I'm just thinking out loud what some of the standard terms are.
Yes.
And then if he honorably graduated probation, we'd have a hearing. If he did what he's supposed to, honorably discharged, and then he could withdraw the no contest plea, the felony goes away, and he's adjudicated guilty of a gross misdemeanor, at which time case is over because credit for time served, no additional punishment.
And the only other thing, Your Honor, that I would add to that is I believe at a previous hearing when this was discussed, Your Honor, indicated from the bench that the court was inclined to follow that negotiation.
Was and still is. I don't know if it's been withdrawn. We're the Wednesday before trial and subpoenas are out, people are ready. We have the veneer here, which I'm going to pass out in just a few minutes. I can't speak for the state, but if you want to know, if that offer were still available right now, would the court go along with it? The court absolutely would go along with it. So, so hold please. I want to make sure that Mr. Handte understands what the court just said. He's got a bit of a puzzled look on his face, and so at the right time, if he said, Judge, can I talk to Mr. Silverberg a little bit more about this, I'll give him time. But right now, that's the deal that was offered and the deal that you communicated, Mr. Silverberg, and to your knowledge, your client understood and rejected.
Yes.
Okay, thank you. Let's turn to Mr. Hillygus. Mr. Stege, what was the last best offer the state presented to Mr. Hillygus or through Mr. Goodnight?
Thank you, Your Honor. And similarly to that, that same notice of the 26th of October, a no plea was on offer, in which the defendant would have pled to count 2 burglary
Well, there was more than one count, wasn't there?
There are, right, at the time, but the ship sailed on that, but at the time, he would have pled to burglary, 1 to 10 years.
Again, no contest, right?
No contest was on offer, 1 to 10 years with, that carries a $10,000 fine, is a probation eligible offense at the time. Reading from the draft, and I caused draft pleas to be sent to both counsel involved in the case. Read as follows. In exchange for my plea of nolo contendere, the state and I have agreed to recommend the following. The state will recommend probation. The parties are free to argue the terms, conditions, and underlying sentence of the probation. The state will not oppose release of the defendant from custody with pretrial conditions to be determined by the court.
At the entry of plea?
Yes, the defendant may argue for diversion. This negotiation is conditioned on both defendants entering pleas that resolve this case.
That was an offer presented in October.
October 26th, I filed notice of available plea negotiations, advising both defendants of the availability of those negotiations, so up until November 9th, 12 p.m. They had to file and execute a copy of the guilty pleas, or no.
All right, so let me go over the terms one more time. At that time, the offer was to Mr. Hillygus, if he pled no contest also to one felony,
Yes.
then, and if the court accepted that no contest plea, a couple things. Number one, at time of sentencing, the state would not ask for prison. Do I have that right?
Yes, you do.
At time of sentencing, the state would not ask for more jail.
Well, it's styled that we recommend probation, and we can argue all the terms, and of course.
Okay, so that was on the table.
Yes, Nevada law allows for jail as a condition of probation, and so that I
Remain to be seen.
remain to be seen. He's done a lot of time in jail. That would be an argument, had that happened.
Well, that would have been honestly a hard sell to say 30 more days would make
Yeah.
Philippines difference under the circumstances that the court would have found itself in, but you never know.
We never know, and that's why
Okay,
I would have.
but no prison, the ask would not have been for prison.
It's an affirmative recommendation for probation.
Affirmative recommendation from probation, and unless the court, and then Mr. Hillygus could get out of custody at the time of the, if he accepted the no contest plea offer, get out of custody, and then when he came back for sentencing, probation, the state would argue for, and the terms of which may or may not have been for an additional ask of jail time. No coming back later if he successfully completed probation to withdraw that plea and turn it into a gross misdemeanor, with the asterisk that he could ask for a diversion. And if he successfully completed diversion, then that case would go away completely. True?
Yes.
Okay, that was
It
the
allowed for an ask of diversion.
Okay. All right. So, Mr. Goodnight, did you hear all that? And if so, was that offer communicated to Mr. Hillygus, and did Mr. Hillygus and you discuss it?
Your Honor, that offer had not changed since the time of the settlement conference, and he rejected it then, he rejects it now. I believe he understood it.
He rejects the offer, which would have one no contest plea to a felony, no prison time, probation, asked for release from custody at the time of the, if the plea were accepted and the court accepted it after a canvass. The answer then was no, remains no to this day.
Correct.
Okay. So, Mr. Hillygus, confirming what Mr., you don't have to tell me the reasons why, but did Mr. Goodnight just accurately reflect to you the response you asked him to communicate to Mr. Stege?
So we didn't have a chance to discuss that until just a few moments ago. I believe that it was delivered to Mr. Goodnight. I did get a copy of it, but he and I did not talk until today.
Okay, hold right there. Let me ask you this. Is anyone in favor of the court going off the bench and coming back in 20 minutes or is that a waste of time? Because when we come back, the next thing we're going to do is have a hearing on the motion to quash the subpoena that was filed on behalf of Barry Hillygus. But does anyone need more time now that we've had this canvas under Fry and under Lafler?
I could have just a minute.
Sure.
Yes.
Hold on one second. Why don't you just for, talk to, please, Mr. Goodnight, just for a moment. I'll stay on the bench. We'll go off the record. And in a moment, tell me if you want me to take a 20-minute recess. And if you say no, fine. If you say yes, I'll happy to do it. All right, so let the gentleman,
Your Honor, my first.
hold on a second. So, gentlemen, here's the thing. We've just taken a moment. The only question right now is, would a 20-minute break be of assistance to anybody?
I don't believe so, Your Honor. My first actual ask was to confer with Mr. Stege to see if that offer was on the table anymore as to Mr. Handte, and it's not, so there's nothing to talk about.
Okay? Well, the purpose of the canvas is to find out what offers were communicated and to make sure they were communicated to counsel and to client. Mr. Goodnight, any reason we should take a 20-minute recess
I don't think so, Your Honor.
based on what we just heard?
Right, he's not saying he wanted the deal at any time after the settlement conference. He didn't want it at the settlement conference, we talked about it ad nauseam.
Okay, do me a favor, slide your microphone over right next to the edge of the table, make sure it's on, and speak up, please.
So I'll repeat what I said, at the time of sentencing, both the settlement conference, we talked about this negotiation ad nauseum. Went through the no contest plea memorandum. He had distinct questions about some of the terms that the state was unwilling to change and decided not to accept the offer. So that's where it was then, that's where he is today. I don't think another 20 minutes is going to change that. It's also my understanding that the negotiation is no longer available.
Okay.
The state's not offering.
Mr. Stege, any reason we should take a 20-minute recess and resume this hearing at 9:45?
No, thank you.
All right, thank you, let's move forward.
I need to address a few things regarding that.
Well, hold on, the question is that if we're done with the process of asking about negotiations or offers, I should say, then I want
It's
to,
regarding negotiations.
I'm sorry, I need you to not interrupt. I can't get you both at the same time.
hold on. We're at the point now where the court is prepared to thank and excuse Mr. Goodnight. He was asked to be your counsel for purposes of plea negotiations, if any, and to respond to the court's pretrial hearing today to see if where things stood.
This is regarding Goodnight and this plea negotiation. I
Say
have
that.
not had a chance to address the court regarding that.
Well, here's my question. Was that offer extended to you through Mr. Goodnight or through Mr. Stege?
The problem with the offer is it's illegal to make an offer when you're concealing and withholding evidence.
Hold.
You cannot go into a negotiation
Mr.
when you're
Hillygus,
withholding
Mr.
information.
Mr. Hillygus, we're not here about that right now.
Well, but that's what it's all about.
Well, I
It's a
understand that's your
crime.
view,
It's a
Mr.
crime.
Hillygus, you're gonna have to stop talking. And this can't be how it goes at trial, or I'm gonna warn you, and then I'm gonna warn you in front of the jury, and then you're gonna be held in contempt, then you're gonna be removed from the court. I don't want that. Here's what I'm gonna do. Here's what I'm gonna do. I'm gonna exercise some judicial prerogative here. The court's in recess until 9:45. If there are issues that counsel wanna talk with each other about, if counsel wanna talk with clients or talk with Mr. Stege, I'm gonna give you 20 minutes to do so. 9:45, we come back, and unless something else changes, we're gonna take up the motion to quash the subpoena. Court's in recess till 9:45.
All rise. All rise. This court is again in session.
Please be seated. Okay, we're back on the record. I'm here with counsel and the two defendants. You took the opportunity of the time we took on the break. Things were being printed out in my office and people were bringing them back in here. Has there been a resolution, and if so, please, Mr. Stege, what are the terms?
Resolution has been reached, similar negotiations as discussed as to Mr. Handte. He's going to plead guilty to...
No contest?
I'm sorry, no to the burglary offense.
Which count is that, please?
Count two.
As count to, Your Honor,
Okay.
in exchange for his plea as contained in paragraph 7. The state will not oppose probation. The term of probation shall be for a fixed term of 3 years. The parties are free to argue all their terms, conditions, and the underlying sentence of probation. Upon entry of plea, the defendant agrees to remain on GPS monitoring and house arrest until sentencing. All their conditions are to remain in effect. If the defendant successfully completes probation, including earning an honorable discharge, he may withdraw his plea and plead guilty or no contest to conspiracy to commit burglary, a gross misdemeanor offense, and receive credit for time served. This negotiation is conditioned on both defendants entering pleas that resolve the case. It should be noted Judge, that paragraph 12, pursuant to Cripps and NRS 174.035 sub 4, and the Supreme Court rules, this is a conditional plea in that it's conditioned on the court accepting the terms of this agreement.
Okay, before you move on to Mr. Hillygus, Mr. Silverberg, did Mr. Stege accurately state the terms of the negotiations upon which this matter will resolve as to your client?
He did, Your Honor.
Thank you. Mr. Stege, as to Mr. Hillygus, please.
As to Mr. Hillygus, he also no contest plea to the offense of burglary as contained in count 2. It should be noted this offense, as to both offenses, is a 1 to 10 year offense to $10,000 fine. It is a probation eligible offense.
Okay.
Paragraph 7 outlines the negotiation with respect to Mr. Hillygus and reads, the state will recommend probation. The parties are free to argue the terms, conditions, and underlying sentence of the probation. The state will not oppose release of the defendant from custody with pretrial conditions to be determined by the courts. The defendant may argue for diversion. This negotiation is also conditioned on both defendants entering a plea that resolves the case. Similarly, paragraph 12 contains information for the following language: pursuant to Cripps, NRS 174.035 sub 4, and Nevada Supreme Court rules. This is a conditional plea in that it is conditional on the court accepting the terms
Okay.
of this agreement.
Thank you. Mr. Goodnight, did Mr. Stege identify the terms upon which Mr. Hillygus has agreed to resolve this matter?
He did, Your Honor. There was some additional language on page 6 of the no contest plea memorandum that just clarifies that Mr. Hillygus is representing himself, and therefore he has made himself aware of the charge, the facts, and possible defenses, and that the role of standby counsel is to assist him in negotiating and executing these negotiations.
Okay.
So I just wanted to clarify that because we're in a little bit of a unique situation here. I believe Mr. Hillygus is going to ask the court to appoint the Public Defender's Office to continue representation of him at sentencing, but I asked the court to canvass that him in that regard as well.
Understood. Gentlemen, if you could please hand the court the signed no contest plea memorandum, one for each client.
And there was one typo on page 2 that the court will recognize. We tried to get all the typos fixed prior to submitting to the court. It just recognizes the indication that when the charge was first filed, it was under AB 15 from 2019, and now it's assigned an NRS, and so we just caught that typo and fixed it.
Okay, did somebody change it and initial it, or you're saying that you'd like it to change at some
We
point?
changed it and initialed it
Okay.
on page 2, if you can refer to the line of record.
Okay.
That's right.
So here's what happens next, Mr. Hillygus and Mr. Handte. I need to canvass you. I need to ask you some questions. I'm placing you under oath to truthfully answer questions to the court, so I know that you're entering into these agreements of your own will. Mr. Hillygus, unless you're medically unable to do so, would you please stand up?
I'm going to remain seated.
I'm going to need you to take an oath to truthfully answer my questions. You understand that? Then, gentlemen, if you could please both raise your right hand. You swear or affirm that the testimony you will give in response to the court's questions will be the truth, the whole truth, and nothing but the truth, so help you God. Mr. Handte?
Agree.
Thank you. Mr. Hillygus? You may put your hand down. All right. This will apply to both of you, so I'll ask you this. Mr. Handte, is it your intention to plead no contest to the one charge being count 2 in the amended information?
Correct.
Mr. Hillygus, is that your intention as well?
Yes, it is.
All right. Do you understand that under Nevada law, the sentencing range for that charge is 1 to 10 years Nevada Department of Corrections, probation eligible, diversion eligible, and that the state is not asking the court to impose a prison sentence? Do you understand that, Mr. Handte?
Yes.
Do you understand that, Mr. Hillygus?
I do.
Do you further understand that in the very unlikely event that the court would vary from the negotiations, you have the right to withdraw at time of sentencing? Do you understand that, Mr. Handte?
Yes.
Do you understand that, Mr. Hillygus?
I do.
All right. Do you understand that if the court accepts these no contest pleas, the trial will come off, it will be vacated, it won't happen? Do you understand that, Mr. Handte?
Yes.
Do you understand that, Mr. Hillygus?
I do.
If there had been a trial, Mr. Stege would attempt to prove beyond a reasonable doubt that you committed these crimes. Your attorneys, in your case, Mr. Handte, your attorney, and in your case, Mr. Hillygus yourself, would have been able to defend yourselves, make argument to the court and the jury, introduce evidence, cross-examine witnesses. None of that will happen now because of these no contest pleas. Mr. Handte, do you understand that?
Yes.
Mr. Hillygus, do you understand that?
I do.
Has anyone, let's start with you, Mr. Handte, has anybody threatened you or somebody you care about with physical harm, for example, to make you plead no contest against your free will?
No.
Mr. Hillygus, how about with you? Has anybody threatened you with any kind of physical harm or anyone you care about to have you enter this no contest plea today against your free will?
No.
Did each of you review and sign your respective nolo contendere plea memorandum? Mr. Handte, did you review yours?
Yes.
And Mr. Hillygus, did you review yours?
I did.
Did you have an opportunity, in your case, Mr. Hillygus, to discuss it with Mr. Goodnight?
I did.
Mr. Goodnight, were you able to discuss with Mr. Hillygus what's set forth in the nolo contendere plea agreement?
Yes, Your Honor.
Thank you. Mr. Handte, did you go over this with Mr. Silverberg?
Yes.
All right, and Mr. Silverberg, did you have a chance to discuss this with Mr. Handte?
I did.
Mr. Handte, is that your signature that appears on the last page?
It is.
And Mr. Hillygus, is this your signature that appears on the last page of
Yes,
yours?
it is.
All right. Mr. Stege, would you please identify the charge as to each, and then I'm going to ask them for their no contest plea.
Mr. Hillygus and Mr. Handte, the offense to which you are entering no contest pleas is contained in the amended information, that is burglary. The elements of that offense are that you, on or about August 8th, 2019, within the County of Washoe, State of Nevada, did willfully and unlawfully enter a certain building known as Stone Valley Alzheimer's Special Care Center, located at 6155 Stone Valley Drive in Washoe County, Nevada, with the intent then and there to commit second-degree kidnapping therein. That you are responsible under one or more of the following principles of criminal liability, to wit, that you did directly commit the acts constituting the offense, and or, 2, pursuant to a conspiracy to commit the offense whereby each co-conspirator is vicariously liable for the acts of the other co-conspirators when the acts are done in furtherance of the conspiracy. And or that you aided and abetted, counseled, encouraged, commanded, or procured each other in the commission of the offense by the said defendant Roger Eugene Hillygus procuring, encouraging, or recruiting Stewart Handte to aid in the offense. The defendants did then contact or attempt to contact Reno Police Department staff in an effort to use the influence of Stewart Handte as a former law enforcement officer. The defendants, upon agreement meeting outside of the facility, where they further planned the removal of Susan Hillygus. One or more of the defendants did then enter the facility. One of them, or an unknown third actor, wrote a fictitious name in the visitor's log, or signed in under the guise of visiting a resident, or otherwise misinforming Stone Valley staff of their intentions. One or more of the defendants then escorted Susan Hillygus from the facility. The defendants then fled the scene together.
Mr. Handte, did you hear the charge that Mr. Stege just read?
I did.
What is your plea to that charge?
No contender.
Thank you. Mr. Hillygus, did you hear the charge that Mr. Stege just read?
I did.
What is your plea to that charge?
No contender.
Fair enough. The court finds that as to each defendant, they understand the nature of the charge against them, the consequences of their nolo contendere plea, and they have made an informed, intelligent waiver of their constitutional rights to have the trial vacated. Therefore, the court does accept their nolo contendere pleas. Sit tight for a minute, a couple things to cover with the gentleman. First of all, the trial is vacated. The motion to quash subpoena is now moot. All right, here's what happens next. I'm ordering that Mr. Hillygus be promptly released from custody.
Your Honor, can we address that?
Say it again.
Can we address that
Sure.
briefly? I explained to Mr. Hillygus that as part of the negotiation in this case, he doesn't have anywhere to go at this point. And so he's not asking the court to release him prior to sentencing. I explained to him if we can arrange somewhere for him to stay, or if he wants to find somewhere to stay between now and sentencing, we can come back and request a hearing from the court. At this point, he's not asking to be released.
It's an unusual situation we find ourselves in because on the one hand, I understand his situation is unique. On the other hand, of course, it's not a hotel. And I'm going to assume that this may have been unexpected for this matter to resolve under these circumstances this morning. But it's an unusual request. I'm not prepared to say he stays in custody pending sentencing on the no contest pleas, but he doesn't have to, I'm not going to push him out of the jail today or ask the jail to drop him off at the homeless shelter. I think we need to come up with a plan here that takes into account his circumstances and does right by everybody. What's that plan? I'm not sure. I haven't really seen anything like this, but I'm willing to listen to reasonable alternatives. The entirety of the 45 or 60 days, not likely the court to go along with that, but that doesn't mean I wouldn't. Mr. Stege, do you have a strong view of this, one way or the other?
My view of it is our negotiations contemplate appropriate conditions of release. I am sort of hearing the defense saying they're not prepared to sort of offer up those conditions. Of course, we cannot forget the issue of flight in this case, so when that decision is made, I would like to be heard on appropriate conditions, is all I'll say. I understand.
What would you have the court order right now?
No contact with Stewart Handte, that he not leave the county of let's say northern Nevada counties up until, let's say, Winnemucca, and that he be on pretrial supervision.
Well, here, let me tell you this. There's a chance that he might be still in custody at the time of sentencing.
Yeah, and that sounds like a rational choice, right? Rather than subject himself to pretrial service conditions, sort of an unstable housing situation.
Well, let's say uncertain.
Uncertain and to most adequately prepare for sentencing. That's not an irrational decision to decide. I'm here, I have access to the programs I want, I can prepare for my sentencing argument and my...
Okay, so Mr. Hillygus, let me ask you this. Do you want the court to say that your custody status stays the same until I see you again for the sentencing hearing?
Yes.
Okay, so here's what I'm going to do. Subject to the court interacting with the sheriff's office to make sure that this is not a problem with them and otherwise lawful, the court orders as of now, your custody status stays the same as it is. Same terms and conditions. But know this, at the time of your sentencing, unless something that nobody expects were to happen, you will be released from custody on that day. So please make sure that whatever date we set for your sentencing hearing, you have made arrangements to go to wherever you're going to go. You understand that, sir?
Yes.
All right. And then while you're in jail, the Division of Parole and Probation is not here today. They were not directed to be here. There's no reason that they would be here. But they are going to come up and meet with you there and interview you to prepare a report. You don't have to talk to them, but you are strongly encouraged to speak with them. They prepare a report background information, social history, educational history, work history, criminal justice history, anything else important that the court and parties use to become informed at the time of the sentencing hearing. So when they come up and make contact with you, I encourage you to meet with them, be candid with them. They're not there to interfere with this process. They're there to gather information for us all to use. Will they be there next week? Don't know. They'll be there in 2 weeks, maybe, and then they have to write a report. So that happens. Mr. Handte, with respect to your situation, you do need to get up to 475 Valley Road. That's the Division of Parole and Probation. Ms. Stege, do we know when they would want to see him for that interview?
To email the division, they asked that Mr. Handte call them in 3 days to schedule an interview. I have the PSI packets to provide each of them, and then I did highlight the phone number on Mr. Hante's packet that you call to set up that interview.
Okay. So, Mr. Handte, I know there's a bit going on right now, but don't go there yet. Call them first, set up a time, then get up there and have that interview. Let's see, what else? Mr. Hillygus, do you want the court to appoint somebody to help you prepare between now and the sentencing hearing?
I do.
And Mr. Goodnight, you are with the APD's office,
I'm at the Public Defender's office, right?
Public Defender's office.
Questions understandable.
Say it again.
Questions understandable.
Switch.
Yeah, I'm sorry if I missed. All right. Well, is there any reason that the court would be unable to appoint the Public Defender's office as counsel to assist from this period of time through the sentencing hearing? Can you think of any, Mr. Goodnight?
I would just want the court to canvass Mr. Hillygus in regards to when he has appointed counsel to represent him in sentencing. It's the appointed counsel that makes the strategic decisions. I'm going to work to his goals, and I think we line up on his goals at this point. But again, he doesn't drive the bus as counsel.
Okay, so there you go. So Mr. Hillygus, here, you heard what he just said. That's the court's position as well. If I appoint Mr. Goodnight or his firm, the Public Defender's Office, to represent you, they're your advocate. You have a chance to address the court at time of sentencing. Your voice will be heard, your views will be heard, but the strategic decisions, the first person to speak, that would be your attorney. So would you like an attorney appointed now that you've thought about it a little bit more, or would you like to continue to represent yourself?
I'll take Mr. Goodnight's representation.
Okay, as in you'd like the court to appoint his office?
That's correct.
All right, so ordered. Mr. Handte, your pretrial supervision remains in effect pending sentencing. Stay in touch with Mr. Silverberg. He's going to be your advocate. Of course, we'll hear from you in time of sentencing. Get up to the PMP interview. What else, Mr. Stege?
With respect to that subject, nothing else. I just ask that the court, because it is a no contest plea, that I ask that the court adopt as a factual basis the transcript of the preliminary hearing had in this matter as a factual basis to support the plea.
Well, the court does need to rely on something in order to find there's a factual basis upon which the plea is made. That's as good as any idea. Mr. Silverberg or Mr. Hillygus, would you like to be heard on that?
Sure.
All right, Mr. Hillygus? All right, the court does adopt those then as the factual basis. Gentlemen, thank you for your hard work this morning. Ms. DeGainer, when will the date and time of sentencing be, please?
Yeah, would you make a special set or?
Yes, no, special set, please.
End of calendar or an afternoon set?
Afternoon.
Yeah, afternoon at 1:30 start, please.
We could do 1:30 on March 28th.
Gentlemen, March 28th, work for the state?
Very good.
Defense?
I believe that'll work, Your Honor.
All right.
If there's any problem, I'll let the court know.
Okay, Mr. Goodnight?
I look like I'm available. Thank you.
Okay, gentlemen, thank you. We'll see you then, the court will be in recess.
Thank you.
All rise.